Subscribe to our channel and press the bell icon to never miss an update from Rao's IAS. Do not forget to subscribe to our Telegram channel for all the updates and materials.
Hello and welcome to Daily Prelims Practice, a series of videos where we practice MCQs from Indian Express and The Hindu. The questions which we are going to take up today have been displayed on the screen. But before we begin the discussion, there is an important announcement. Just like in case of DNS, we used to practice these in attemptable form on eLearn platform, you can do that right now also. All the DPP questions which are discussed in the video are available on eLearn platform, as you can see on the screen, where you can go and attempt them. Let us now begin the discussion.
So this article appears on page number 7. From Lodha to Ramanna, the Chief Justices of the Modi era appears on page number 7 on The Hindu, which talks about the terms of various Chief Justices to the Supreme Court of India and what were the important decisions taken during their tenure. Now, the Supreme Court of India and judges of the Supreme Court have been an important theme for the prelims examination, as you can see from this question which was asked in 2019 with respect to the process of removal of the judges of Supreme Court. And so, the practice question on your screen is regarding the appointment of Supreme Court judges. Consider the following conditions, and you have to identify which of the conditions given above are mandatory for the appointment as a judge of the Supreme Court of India. So of course, first statement is correct according to Article 124 subclause 3. Without being a citizen of India, one cannot become judge of Supreme Court. But apart from that, there are 3 conditions as well, and this is also one of those conditions, but it is not mandatory. And so a person possessing citizenship and any of those 3 conditions is entitled to become judge of a Supreme Court, and hence this does not form the part of the right answer, leading us to the correct answer A1 only. Question number 2 has also been taken from The Hindu, page number 8. Scandinavian social democracy. Now if you look at previous year questions from political theory, testing you on basic political concepts have become very important. For example, in 2021, this question on liberal democracy. And since the term social democracy appears in the newspaper, let's solve this question. Which of the following statement best describes the term social democracy? Statement 1 is of course incorrect because it initially envisaged a transition of society from capitalism to socialism, but now it has been modified. It has been modified because now it prefers state regulation rather than state ownership, and which is the correct answer. Whereas both statements C and D are incorrect because it takes stand against totalitarianism, and although it shares common ideological roots with communism, but it does not support militancy, and hence the statement D is also incorrect, leading us to the right answer B. The next question has been taken from an article appearing on page number 6, the hijab case and the essential practices doctrine. Now, essential practice doctrine has direct bearing on the freedom of religion guaranteed as a part of fundamental rights. Now, fundamental rights have always been an important theme in civil services prelims examination. If you look at this question in 2019, the question was with reference to one's right to marry the person of one's choices, and which article did it connect to? And we know that there is no direct reference of right to marry in Article 21. And so the question on essential practice doctrine. Consider the following statements. Statement 1 says, Constitution of India under Article 25 defines essential religious practice, and based on this, wearing and carrying of kirpans has been included in the profession of Sikh religion, which is absolutely incorrect because Constitution of India under Article 25 does not define essential religious practice. The second statement is, the state cannot regulate or restrict any economic, financial, political or other secular activity which may be associated with religious practice as per Article 25. Now this statement is also incorrect because under Article 25 clause 2 subclause A, the state can regulate or restrict any economic, financial or political or other secular activity which may be associated with religious practice as per Article 25, and so the right answer would be neither 1 nor 2. The next article that we have taken is from The Hindu, page number 9. The significance of Ethereum's merge for the future of cryptocurrencies. So Ethereum has switched to a new way of verifying transactions on blockchain. And so in this regard, We already know that emerging themes in science and technology like CRISPR-Cas9, blockchain, Internet of Things, augmented reality have been very important in past 5 to 10 years. For example, in 2021 itself, UPSC checked us on blockchain technology. And so in this regard, the question is, consider the following statements. Statement 1 is, cryptocurrency is an unsecured and decentralized form of digital currency. Which is of course incorrect because cryptocurrency is decentralized digital money that is based on blockchain technology and secured by cryptography, which is a method that secures data from unauthorized access by the use of encryption technologies. Statement 2 is crypto tokens do not have their own underlying blockchain, which is of course correct because a cryptocurrency, as we all know, can be in form of coin or token, depending on whether it's the native cryptocurrency for its own blockchain or not. Crypto coins have their own underlying blockchains, but crypto tokens do not. For example, crypto tokens built on top of Ethereum include Matic, Link, and USDT among others. So Ethereum has a blockchain at the base, but Matic does not. So this statement is correct. Statement 3, crypto coins can be mined, but crypto tokens cannot be mined is also correct. Because mining is a term which is associated with something which is limited. The coins are limited, they can be mined, but tokens are made. But since tokens are based on blockchain coins, they are unlimited and hence the mining is not the term which is used in that reference. And so the right answer is 2 and 3 only, B. Let's now move on to the Indian Express. The first question that we have taken has appeared on page number 10, securing basic structure. Now the basic structure doctrine is not only important from the perspective of mains examination, but also from the perspective of prelims examination. As you can see, in 2020, UPSC had framed a question which included basic structure and judicial review because both of them are interconnected. So the practice question for today is, consider the following statements regarding doctrine of basic structure. Statement 1, the amending power of Parliament as under Indian Constitution are absolute, which is of course incorrect because the amending power of Parliament are not absolute but limited as adjudicated by Supreme Court in various cases starting from Keshwanand Bharti to Minerva Mills, and also concluded that limited amendment powers is a basic feature to the Constitution of India. Second statement, the courts have the power to invalidate not only executive but also legislative enactments that violate fundamental rights, is of course correct because Indian courts do have the power to invalidate not only executive but also legislative enactments if they violate any of the features provided under the Part 3 to the Constitution of India. Statement 3 is, the doctrine of basic structure has been mentioned explicitly under the Indian Constitution is of course incorrect because it is a judicial innovation and it is not mentioned in the Constitution of India, leading us to the right answer C, 2 only. The next set of 2 questions have been inspired from an article appearing on page number 11 in Indian Express. Time for global digital governance. India's G20 presidency is a chance to address challenges of regulating the big tech. Now, whenever important international grouping like G20, BRICS, SCO appear in the newspaper, membership of these groups are very important and they have been tested. But apart from that, what also has been tested is important initiatives taken by these important groupings. For example, G20 Common Framework in 2022. And so the question, with reference to the Global Partnership for Financial Inclusion, consider the following statements. Statement 1, it was finalized at the Rome Summit of G20 in 2021. So the Global Partnership for Financial Inclusion is an inclusive platform for all G20 countries, interested non-G20 countries and relevant stakeholders to carry forward work on financial inclusion, including implementation of G20 Financial Inclusion Action Plan. And it was finalized at G20 Summit in Seoul in 2010 and not at Rome in 2021, and hence this statement is incorrect. The second statement says World Bank is one of the implementing partners. And so at Rome, G20 leaders committed themselves to enhancing digital financial inclusion of vulnerable and undeserved segments of society, including MSMEs. World Bank joined this initiative as an implementing partner in 2012. And so this statement is correct, leading us to the right answer B, 2 only. Apart from this, article also mentions the Digital Markets Act. Now generally, The legislations created by developed countries are not important unless, for example, in 2019, UPSC had asked a question on General Data Protection Regulation. And so this editorial mentions the Digital Markets Act, which aims at preventing large companies from abusing their market power, and it is of course an initiative of European Union, which aims to ensure a higher degree of competition in European digital markets by preventing large companies from abusing their market power and by allowing new players to enter the market. The next article that we have taken has appeared on page number 13, the controversy over NAAC's system for assessing higher education. So the National Assessment and Accreditation Council has come into news because of its assessment parameters. And so, in this regard, you can already see institutions like National Innovation Foundation of India, NIF, has already been tested in 2015. And so in this regard, we have formulated this question. Consider the following statements. Statement 1. National Assessment and Accreditation Council is an autonomous institution, which is absolutely correct because it is an autonomous body under the University Grants Commission or UGC, which assesses and certifies higher educational institutions with gradings as a part of accreditation, and so the second statement is also correct. Now we know that it has a system of rating, and so the third statement is on that. The ratings of institutions range from A plus to C, which is incorrect. The rating of institutions range from A double plus to C, and so the statement 3 is incorrect, leading us to the right answer A, 1 and 2 only. Apart from this, if you had known through the newspaper reading that the ratings range from A++ to C, you could have easily eliminated all other options which contain 3 in them, and then also you would have arrived at the right answer A. Last question for today has appeared on page number 13, the CBI's uneasy history. So SC has called it a caged parrot already, and the CJIs have expressed doubts over its credibility and said it is no longer trusted. And so in this regard, we have formulated this question with reference to Central Bureau of Investigation, which is the premier investigating police agency in India. Consider the following statements. Statement 1. CBI functions under the Legislative Superintendence of Delhi's Special Police Establishment Act 1946, Lokpal and Lokayukt Act 2013, and the Central Vigilance Commission Act 2003. This statement is absolutely correct. CBI derives its authority from 3 different acts: DSP Act 1946, Lokpal and Lokayukt Act 2003, and CVC Act 2003. The second statement is the central government can extend the jurisdiction of CBI to investigate any case beyond UTs, but consent of respective state government is mandatory under the law, which is of course correct, because as per section 6 of DSP 1946, consent of state government is required to exercise power and jurisdiction. Statement 3 says, President of India appoints the director of CBI based on the recommendations of selection committee comprising Prime Minister, Central Vigilance Commissioner and Leader of Opposition. Now this statement is incorrect because President does appoints the director of CBI, but it is based on the recommendation of a selection committee comprising of Prime Minister, Leader of Opposition and Chief Justice of India and not CVC. And so statement 3 is incorrect, leading us to the right answer C, 1 and 2 only.
So this is it for today. We'll meet tomorrow at the same time for more practice MCQs.